Judgment in the matter of Walker versus Innospec Ltd and others.
Lord Kerr will explain the judgment of the court.
Some 37 and a half years ago, on the 2nd of January 1980, John Walker started to work for a firm called Innospec Ltd. And he remained in that employment until his retirement in 2003. Throughout the time that he was employed, he paid into Innospec's contributory pension scheme. Now, Mr. Walker is gay. He's lived with his partner since 1993. As soon as they could, Mr. Walker and his partner applied for a civil partnership, and that was registered in January 2006. They are now married. Shortly after they entered into the civil partnership, Mr. Walker asked his employers to confirm that they would pay a spouse's pension. A spouse's pension is provided for in the pension scheme. And he asked whether they would confirm that they would pay that pension to his partner in the event of Mr. Walker's death. The company refused to confirm that, and they maintained that stance after the couple married. Now, in fairness to Mr. Walker's former employers, they were entitled to take that position under the law as it then stood. His pension contributions had all been made before the 5th of December 2005. That's an important date because it was the date on which civil partnerships were introduced to the United Kingdom. The Equality Act of 2010, in broad terms, prohibited discrimination on a number of grounds in relation to employment. Those grounds included sexual orientation. So Mr. Walker considered that his employer's refusal to confirm that on his death they would pay to his spouse the pension that the scheme provided for, that represented discrimination against him on the grounds of his sexual orientation. But the Equality Act contained an important proviso. Paragraph 18 of Schedule 9 to the Act said that it was lawful to discriminate against an employee who is in a civil partnership or same-sex marriage by restricting them from access to a benefit which accrued before that important date of the 5th of December 2005. And most importantly, it provided that they could be restricted from access to the benefit which was payable in respect of periods of service before the 5th of December 2005. And as I've said, Mr. Walker's period of service ended in 2003. His case, therefore, fell within the proviso, and under the Equality Act, the employers were entitled to refuse to pay the spouse's pension. It was clear, however, that under the terms of the Act and the provisions of the pension scheme, if Mr. Walker married a woman, even after his retirement, indeed even now, she would be entitled to a pension. So this case, therefore, centred on the question whether paragraph 18 of Schedule 9 to the Equality Act could be allowed to stand. Of course, the courts of this country do not have power to strike down legislation which our sovereign parliament has enacted. But we do have the power, indeed we have the duty, to disapply provisions in legislation which are in conflict with European Union instruments from which they are derived. In this case, the European Union instrument was the Framework Directive 2000 of 1978. 1978 of 2000. That directive prohibits discrimination in the field of employment on the basis of sexual orientation. The essential question, therefore, in the appeal was whether the provision in the national legislation, that's paragraph 18 of Schedule 9, which allowed Mr. Walker's period of service to be left out of account could be reconciled with the terms of the directive. The question required a review of relevant decisions of the Court of Justice of the European Union. In the final analysis, this court has unanimously decided that it was clear that the fact that Mr. Walker's right to a pension for his spouse was earned during a time that discrimination on the grounds of sexual orientation was not against national law was irrelevant. What mattered was that at the time that the pension would become payable, it would be against the law to discriminate against him on the grounds of his sexual orientation. We have therefore allowed his appeal and made a declaration that insofar as paragraph 18 of Schedule 9 to the Equality Act authorises a restriction of payment of benefits based on periods of service before the 5th of December 2005, it is incompatible with the Framework Directive and must be disapplied. We have also made a declaration that Mr. Walker's husband will be entitled to a spouse's pension on Mr. Walker's death, provided, of course, that they remain married.